My name is John Watts, and I am a consumer protection attorney in Birmingham, Alabama, and I sue abusive debt collectors. And one thing that we often face, both from consumers who are trying to figure out what to do with an abusive debt collector, and also from defense lawyers when we sue abusive debt collectors, and that is the idea of, won't a cease and desist or a cease communications letter stop the abuse? So let's talk about that. First of all, there are all sorts of people on the internet that will say, if you are dealing with an abusive debt collector, if you will just send them a cease and desist letter, it'll all go away. It's all over. Okay? Well, then when we sue abusive debt collectors, sometimes the defense lawyers say, well, yeah, we did call your neighbors and we did threaten you and we did lie to you, but you did not send a cease and desist letter. So when you think about it, it's really your fault that my client, the abusive debt collector, broke the law. And we've even tried cases where the lawyers will make this argument. They'll say, you can't expect us as debt collectors to actually follow the law. It's up to the consumer and the consumer lawyer to send a cease and desist letter, because if you had sent a cease and desist letter, this all would have never happened. Well, there's a bunch of problems with that. But here's what we have pointed out in court before. If you think about it, you got an abusive debt collector that's willing to lie, illegally threaten, call neighbors, call family members, willing to risk being sued in federal court, risk having to pay damages, risk having to pay attorney's fees. But the argument is, if they get a little letter that says, stop calling me, do not communicate with me, that they're going to go, well, now we have to obey the law. I don't think that that's a real good argument. And I've not seen a jury persuaded by that argument. And it really is kind of absurd when you think about it, that a debt collector that has a regulatory department, that has all sorts of defense lawyers, corporate lawyers, but yet the only person that can keep them obeying the law is you. It's crazy. I don't even know exactly how to say it. It's kind of like when we were trying a case one time, a debt collector was arguing in his testimony that, well, we didn't do anything wrong because it's not in the notes. If it's not in the notes, we didn't do it. And the judge goes, wait a minute. If you put it in the notes, you'd be fired, right? Yes, we'd be fired. And so your argument is, because you didn't put it in the notes where you'd be fired, it must not have happened. And then she kind of looked off and she said, never mind. And that's kind of the deal with these arguments. They kind of sound nice, and some lawyer somewhere in New York or somewhere thinks this up and goes, I got the answer now. But put that in front of real common sense people, and the whole thing falls apart. So a cease and desist letter can be useful, but if you're dealing with a truly abusive debt collector, I don't think they're going to be particularly concerned about, make sure I follow that part of the law even though I violated half a dozen other parts. So if you're dealing with an abusive debt collector, suggest that you document what's happening and get with a consumer lawyer in your area. If you live in Alabama and you want to chat with us, my name is John Watts. 205-879-2447, or you can contact us through our website, alabamaconsumer.com. Thank you very much.